And good morning, good afternoon, good evening, whenever you're watching or listening to this information. This is your show, Lideres del Futuro. My name is Rafael Vasquez, and today I have the privilege and opportunity to have immigration attorney, Maureen McSorley. And Maureen, first, thank you for taking the time and being with me today.
Thank you, Rafael. Nice
And
to
then,
see you.
yes, and you have about close to possibly 30 years of experience as an immigration attorney. And it wasn't until recently that I have heard about something called the Special Immigrant Juvenile Status Visa. Can you tell us what it is and what is not?
Yes, the Special Immigrant Juvenile Status is for children. It's actually a young adult also, up to the age of 21. If you are under the age of 21 and single, you might be able to qualify for this Special Immigrant Juvenile Status if you can prove that you were abused, neglected, or abandoned by at least one parent, and you are not able to reunify with that one parent. So if you are able to show that, you might be able to apply for this Special Immigrant Juvenile Status. And then if you are deemed a special immigrant in that way, you can then apply for your legal permanent resident status.
Any idea how long the process might take?
Well, it depends on visa availability. If you're from Mexico, historically, the past several years, the wait has been less. There are times over the past few years where there have been visas available immediately, so you could file right away. If you are from Central America, it is currently about a 3 to 4 year wait, I would say.
And so how do people go about applying for this visa? Let's say they determine that maybe, for example, I have a case of a kid whose mother migrated to the United States because the father was physically abusive of the mom and the child. And so they've been living in California for about 12 years now. The child was 2, he's 14 now. Would they have any possibility of applying for the child since they had to migrate as a result of fear of violence from their spouse?
Yes. The first question would be, was the mother married to the father? Depending on the answer to that mandates how we're going to get through the case. So if the couple was married, then we need to see if they need to get a divorce, or if they're already divorced from Mexico, the proceeding would be different than if they aren't divorced. So there are some questions to figure out what type of case it will be. In that type of case, were they married?
They were married.
Are they already divorced, or?
No, she just literally fled to the United States because he was an alcoholic and abusive. And again, she was afraid of what might happen to her and her child. So she migrated to California, and she's been living in the country now for 12 years.
Well, for example, she might be able to file for divorce here in Sonoma County, or if she lives in Sonoma County, she would be able to file for divorce here from him, perhaps. And then once those proceedings are started in the family law court, it is there that we can go and ask for our Special Immigrant Juvenile Status order. So first of all, we have to figure out what type of proceeding do we have. Is it a family law proceeding? Is it a probate proceeding? So that's where the attorney will figure out what kind of a case it would be. You can get these Special Immigrant Juvenile Status orders in any type proceeding where the court has jurisdiction or authority over the child's well-being. So if the court is in a position to make an order regarding the care and custody of that child, you can go into that proceeding and get these orders. So that's where the attorney has to initially figure out, is it a Uniform Parentage Act? So that would be in a case where perhaps the parents were not married. So you would go in and figure out, then you file to prove that one of the individuals is the mother or father of the child. So you start your action. It's either a divorce proceeding or a Uniform Parentage Act or whatever. And then once you get that family law or probate proceeding started, then you can ask for your orders. In that proceeding, you would then file another motion to show, yes, indeed, this child was abused, abandoned, or neglected by one parent. In your hypothetical, it sounds as if they were abandoned by the father, number one, because he has not had contact with them for 12 years. And one of the elements to prove abandonment is if there has been failure to support the child financially. So generally, if there's a year where there has been no child support paid for that child, that in and of itself would be an abandonment. So theoretically. So if a parent fails to provide for that child, that could be deemed an abandonment. If one parent has died, that is deemed an abandonment. So again, and then if the abuse that you talked about in Mexico, that would be very relevant. If the abuse occurred toward the mother or the child, even if it were just toward the mother, the court will consider that in terms of whether the child was abused. And clearly it is not viable that that child reunify with the father because the father has shown he is not willing or able to care for that child. So the court must make that determination also. So you have to prove again that the child was abused, neglected, abandoned by one parent, and that they cannot reunify with that parent, and that it is not in the best interest of the child to return to the home country. So they are the three things that we would have to prove here.
Okay. Last question on this. Would a father or a mother, for that matter, getting deported from the country prove abandonment if they maybe were, it was a result of maybe, or in connection to committing a crime, whether there's maybe drinking and driving that led to this person being deported eventually? Would that include or be deemed to be abandonment?
Yes, if they were not here. Mm-hmm. So if they were deported for whatever reason, they're not here and they haven't financially supported the child or maintained contact, that would be an abandonment.
Okay. Good.
Yeah.
And do I need to, if I'm in a situation like that, do I need to go to a specific immigration attorney? Can any immigration attorney take on these cases? Or is there special type of training or experience that I should be seeking a specific attorney?
You can ask any immigration attorney if they are able to do this type of case, but a lot of attorneys have not done them and do not have experience with them. I will provide you with a list of nonprofits that have attorneys that specialize in this special immigrant juvenile status issue. And again, you can use this to file affirmatively if the child is not in removal proceedings, or you could use it as a defense if the child is in removal proceedings. Okay. So often you have unaccompanied minors that have arrived here in the United States. An unaccompanied minor is one that arrives without a parent and they are under the age of 18. So if often they arrive here and they are immediately placed in removal proceedings. So one defense for which they often qualify is the special immigrant juvenile status. It's a good defense often. So you definitely want to review their eligibility for that if they are in removal proceedings. Often abuse has occurred to the children in their home country. They're often made to work at young ages. I have one now where he was made to work at age 8 and he was not allowed to go to school. Well, you know, we apply the laws of the United States to these cases, not the laws of the home country. Mm-hmm. So labor violations in the United States count to show that that was neglectful. That was neglectful for a parent to allow a child to do that. The abuse, neglect, and abandonment is one standard. You could also do it for a similar basis under the law. So again, a labor violation like that, where children are working, That would not be allowed in the United States, and that often provides the basis for the special immigrant juvenile status orders. And I've done them in the different counties around Lake County, Napa, Solano, Sonoma, Marin. So all of the judges are very different. Some of the counties do not understand the process well. Mendocino, so you really have to educate some judges more than others. The Sonoma County judges are very familiar with this now. They're wonderful, they understand, and they're able to issue the orders more readily than other counties. Every county has their own procedures also, so you have to get in and figure out what their procedures are in all of these cases. If you have a case where a child does not have a parent that is able to care for them, even one parent, then you could do a guardianship. So someone other than a parent could come in and get guardianship of that child, and you could get the special immigrant findings in that kind of a case also. So that's another way to get it done for people. But it's a very good, I think it's a good relief for youth, and it should be identified. If you see any youth that's under 21 and single, they should look into this, you know, see if there's a possibility.
And then finally, there's obviously the issue of DACA, and there's a lot of people who, whether they're in their early 20s now or maybe in their 30s now, and they're concerned about the fact that DACA may disappear in June of 2020. You know, that the court may determine that the president has the power to eliminate the program. What should they be doing now?
Well, our advice has been to try to renew your DACA if you can. Generally, immigration has stated that it is best to renew within 6 months. We have been trying to renew some even beyond the 6-month period just to try to get it in. You must know that you could lose your filing fees if it were to be found unconstitutional. So that has been our advice, is to try to renew. Once the decision is made, it would be a great idea to try to see an immigration attorney so that you can assess if there are other options for you. Everything that you speak with an attorney about, of course, is confidential, so they cannot share it with anyone. So I think it's definitely in your best interest to try to see an attorney, an immigration attorney, and go over your entire situation and see if there's any other relief for which you might qualify with the DACA. And there will be seminars and things and workshops to explain what the decision means. It might be, you know, a rollout type thing where it is paused over a certain amount of time. We just don't have the details about what might happen should it be canceled. So I would definitely watch for information, you know, about what you should do at that point. Good. If it were to be denied. Hopefully not. But.
Okay. And with that, I want to thank you for taking the time and being with me today. Anybody who has any questions, you can always send an email to lideresdelfuturo@yahoo.com. And again, I will have a list of attorneys who can do this type of special immigrant juvenile status, and a list of trusted attorneys in Sonoma County, immigration attorneys in Sonoma County, that I can make available to you there. You can also find this information on my Facebook page, DACA Sonoma County. And finally, you can also go to my podcast, also known as Lideres del Futuro. Thank you, Maureen, for taking the time and being with me today.
Thank you, Rafael.